Hi, everyone. Harry here to talk about a just issued injunction in a case out of Massachusetts involving the Department of Education. An important injunction and a really wide-ranging injunction. Okay, review the bidding. The administration, Trump, has made it a kind of campaign pledge to just get rid of the Department of Education, which was created in 1979 to consolidate all kinds of federal government education functions, plays a really important role in education. It's a little bit even unclear why it's such a hobby horse of certain elements of the right to get rid of it. But anyway, he does a couple things. He forces a reduction in force of like 50%. And then issues an order on March 11th saying, Secretary of Education McMahon, do everything you can to just move the Department of Education to being demolished, shuttered down. Now, this is the same infirmity and same trick they've tried again and again. Congress creates federal agencies. Only Congress can get rid of federal agencies, and at least in court, certainly not in the public arena, they acknowledge that. But the conceit they try to use to get around is to say, we're not closing exactly. We're just paring down like to nothing in order to improve efficiency. It's just administrative. And to do that, we don't need congressional approval. So the gist of the suit by the plaintiffs here, who are a whole group of states and school districts and nonprofit organizations and labor unions, is to say, that's not what's happening right now. Because of what they've done, the Department of Education cannot function. It's basically, been closed down. Only Congress can do that. There, many violations are claimed in the lawsuit, but that's the big one, and it's the cross-cutting one, right? It's the one that the Trump administration really does again and again. We don't care that Congress can't do it. We're doing it anyway. And our legal justification is we're just kind of paring things down for efficiency's sake. Okay, so the judge here, who is Judge Joun, I think, Joun, could be Joun, in the District of Massachusetts, same district as Judge Murphy, who, entered the order in the South Sudan case yesterday, or who found that the administration had violated his order yesterday. Joun, that's probably the better pronunciation, says, you may not do this. First, administrative efficiency, excuse me, I see no administrative efficiency. What I really see is decimation, in a way that it's not even a matter of efficiency anymore. I see non-functionality. And also, and relatedly, I see that you've completely usurped congressional function here. They're the ones that can close things down. They didn't do it, and you can't do it. So it's a 88-page opinion, thorough, etc. The judges are really on to the point that the Trump administration is always going to be seeking emergency relief from the Court of Appeals. They write these thoughtfully and carefully. The suit's been pending for a couple months, and Judge Joun really has a careful focus. But let me just go to the end of it, because the remedial order here is quite strong and comprehensive. So he orders first, the agency defendants, that would be McMahon and Department of Education, are enjoined from carrying out the reduction in force. So remember, it's a two-part thing. Reduction in force, where they got rid of like 50%, and also the follow-up executive order on the 20th and 21st that basically said, take these steps, Secretary of Education, to close down Department of Education, notwithstanding Congress. So, that was really a ham-handed way. And as usual, the department attorneys then have to go into court and, try to do their best with a terrible legal case to try to say here, oh, it's just administrative, et cetera, when you have an actual follow-on executive order from the 20th and 21st basically saying, get rid of it. Moreover, the defendants are enjoined from doing anything to reinstate that executive order or the directive of the next day, so the 20th and 21st. Moreover, the agency defendants shall reinstate federal employees whose employment was terminated or otherwise eliminated after January 20th as part of this reduction in force to restore the department to the status quo such that it can carry out its statutory functions. That's almost always the issue here. Trump does this heads I win, tails you lose strategy where people are, pushed out of their work. And then what? They have to get on with their lives. Often they've done other stuff. So even if the eventual relief comes from the courts, what really should be going on here is Congress should have been saying, no friggin' way, should have been saying it right away and should have kept this from happening. But it's Congress's complete dereliction that makes the courts come into the act, but they are not the best instrument of government to act quickly and to force a reversal here. So that's why, that strategy can be, even when unlawful, can be effective on Trump's part. But here the judge does everything that he can. You have to reinstate. Moreover, you have to give notice to everybody and their agents, lawyers, etc., that I have done this. Moreover, I want to see a report within 72 hours of just what you've done here. And moreover, this is effective immediately. So basically, he's, tying up everything in a bow. And then just one more point. In a different YouTube today, I talked about this kind of legally arcane, but pretty dangerous, pernicious provision in the big, beautiful bill to make plaintiffs who get bonds or injunctions from a court to have to post a big amount of money, to people who get injunctions to have to post big bonds. That's sort of part of the civil rules that happens with private entities. And that would basically shut down this whole business. Trump has, inserted it as a poison pill, and his allies in Congress went ahead and did it. And it says, it says you can't do anything, use federal money at all, even for pencils, unless in this case you've required plaintiffs to post bond. But let me just, whether he knew it was coming, Judge Down or not, here's what he wrote. He talks about that provision, but, the movement has to give security. However, he says, the First Circuit has recognized an exception to the bond requirement in suits to enforce important federal rights or public interests, as is precisely the case here, he writes, and will be precisely the case everywhere else. So in the event that this nasty little poison pill that Trump's, lackeys have inserted in the big bill passes, this is what you're going to see. It'll be challenged by the administration as they challenge anything that A, harms them, and B, involves inherent judicial power. But if inherent judicial power means anything, it has to mean the ability to enjoin unlawful action without requiring a bond. So I think that'll be the direction we go to. I just wanted to point that out in light of the provision that just last night was stuck into that bill. Okay. So Department of Education, Massachusetts District Court, no. The reduction in force is out. The order saying go toward demolition is out. Everybody who lost their job is back in. At least that's the order. They have to get notice so they can be, et cetera. Basically as strong as it could get. You'll see the administration try to appeal now to the First Circuit, a pretty progressive court. I don't see their chances being that great there. And then the Supreme Court, but, Department of Education, there's no doubt that they have bypassed Congress. They can't say otherwise. And so their legal claims may not be very strong. And, the Supreme Court's not going to take every single case. This is a big one and an important one and a sort of fundamental one in that it strikes a decided blow in favor of the proposition, sorry, administration, you can't simply weed in Congress's garden and shut things down, or do the same by claiming administrative efficiency, but you're really still violating the law. That doesn't cut it. Preliminary injunction entered. Hire everyone back. There you have it. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.